Fact that I am. She gave me is that she has like a plan in her head to produce a book, fictional book about smoke jumpers, and it's all kind of laid out to the soundtrack of Led Zeppelin.
So I heard this summer in undergrad, and we like listened the whole summer to Led Zeppelin on nonstop. Developed this book. Someday I will have time to like get down with it. I'll have to just listen to Led Zeppelin when I write.
That's the short and sweet version. Is there anything you
Awesome.
want to add?
Thanks, Tyler. And poor Tyler, he asked me for some feedback, and it's just been a crazy week. So Tyler, thank you for doing that on the fly. Sorry, it's been a crazy week on my own. Awesome. Sorry to those of you who are in public lands. You get to hear me talk like 3 straight hours today. Sorry. But yeah, nice to be here. And this is some early work from my sabbatical. So I was on sabbatical during spring semester based in Salzburg, Austria, and using that time to kind of understand the framework for European wildlife law. And Mari is here and has a true understanding of European wildlife law, so she's going to help me if I stumble. And this is based, this presentation is one that my colleague Madeline Cass, who's at the University of Seattle, but does a lot of visiting, teaching and scholarship in Europe, that we put together for a conference in Cork, Ireland on environmental law. So I would say this is like kind of some fun information. This isn't like hard-hitting scholarship, but this is the start of my exploration of European wildlife laws, just to kind of understand a comparative analysis. And I'm now embarking on kind of a deeper dive, maybe in particular to carnivore management and delisting and listing. So this is a little bit of a lighthearted presentation. So sorry, it's not deep hitting scholarship, but that will come later. So. And I would say Madeline covered the habitat and the bird section of this presentation, which I'm going to cover today, but that was her original work that I'm presenting from. Okay. There we go. Okay. So, and I should say, Madeline and I are right now putting this together into an article that we're publishing through that conference that we presented to. So we start off the article in the presentation by talking about, why is it helpful, first of all, to do comparative analysis and why on wildlife law. And so Madeline has done a lot of comparative analysis work and has some really great quotes in some of her articles that talk about, by doing comparative analysis work, not only do we understand the legal framework in another part of the world, but it also helps deepen our own understanding of our own system as to what may be working well and maybe what's not working well. So not only can we then compare and maybe learn things that others are doing that would work well in our situations, but we can kind of assess or self-reflect on the laws that we've created here in the United States and think critically a little bit more about them. And so why do we pick wildlife? Well, that's something we're both interested in, do a lot of scholarship in, and just, addressing what, was identified by the IPIS committee in 2019 about, the really concerning decline of wildlife worldwide. And that's something certainly both the US and the EU themselves are experiencing, despite being two, sort of leaders in conservation of wildlife law. We're still seeing pretty drastic declines of wildlife, both in the US and the EU, including 39% of species having a poor or bad conservation status in the European Union, and in the US, up to a third of all US species currently being at risk of extinction. So even though we have these robust laws, we still have these declines. So what can we do to rethink these laws and think more about how we can improve the outcome for species? And that begins with kind of doing a deep dive into understanding what they are, to understand how we may change. So here's a roadmap for where I'm going to go today. So I'm going to talk about kind of the origins of law in the US and EU, because they are quite different, and the foundations for wildlife law in both places really matter in terms of where they're at today. So it's helpful to understand where they started from. Talk about birds conservation, and then protected or at-risk species conservation, habitat conservation, then just a few minor points looking forward. Okay, so I think this was the most fun part of sabbatical research for me, was understanding the foundations of wildlife law in Europe, which is hard to do, right? Because Europe is made up of many different nationalities that come together to make the European Union. And so each one has a different story to tell with regards to sort of their origins or wildlife law. So what I have attempted to do is kind of put my arms around that story and kind of present it writ large, but that's hard and tricky to do. But in general, we can talk about after the fall of the Roman Empire, then individual monarchs of these companies typically held all rights to wildlife and would grant them to their friends and family members. And so, hunting wasn't something that was guaranteed to the public. It was kind of more of an elitist or a wealthy person's sport. Obviously, there were needs for poaching and for feeding your family, and actually kind of great lore about poachers in parts of Europe and sort of respect for poachers as they needed to get meat to feed their families and kind of, as a take that aristocracy kind of action. But as the monarchs began to be dissolved, then we see that power being then passed down to the government of different member states. And so that is a point to make. And then we see the creation of the European Union, which initially was just focused on sort of economic collaboration, but then has started to evolve, and now is really sort of what they call a supranational governmental authority, which oversees, environment as well. And actually some of the conservation and wildlife laws were the first tiptoe by the European Union into the environmental regulation space, and now they have really grown to cover all things. And so the main European laws, and I'm going to talk about the EU level in this presentation, include the Habitats Directive and the Birds Directive, and those are really the cornerstones of their wildlife and conservation law. But those directives cover some detail, but they leave the implementation up to the member states. So each member state then implements the Habitats and the Birds Directive, but they put their own cultural and historical spin on it, and they implement it based upon how it makes sense for their individual countries. And then in the US, the origins of wildlife law, obviously we can trace back to white settlement with the first colonists who, were basing their laws and implementation on the English precedent, which then ultimately relied upon the Magna Carta. And once then after we had the Revolutionary War, the powers that the king held were then passed along to the states. So the states fill in for the king and they manage wildlife, which is considered a public trust resource, which again is based upon English law and the Magna Carta. So states have the authority to manage wildlife, but they do so under a public trust regime or requirement. So states manage wildlife on their own for a long time, but then we see the federal government starting to step in, particularly when states have failed to conserve wildlife, and there's a need to address that on a national scale. We first saw that creep primarily with the Migratory Bird Treaty Act, which was signed with Great Britain in 1918. There were some earlier encroachments into that state space as well, but the first major one was the Migratory Bird Treaty Act to address the decline of birds across the United States as a result of kind of the hat craze of the era. And then obviously the Endangered Species Act of '73 was another big federal action we see, encroaching into the traditional state space of wildlife law. But it's still true today to say primarily states have management authority, but there are instances when Congress has felt the need to include the federal government in oversight of wildlife. So some takeaways, big picture in thinking about the origins of wildlife law. In the US in general, there's a larger role for land owners in the management of wildlife. Some countries like Austria actually put the burden of managing wildlife on large landowners. So they are actually the ones that grant hunting rights. And then they have a responsibility to feed in the winter if the government decides that's something they need to do. And they have a responsibility to keep the herds at kind of a manageable level as well. Versus in the US, that's action that's primarily taken by state agencies. In fact, some landowners are forbidden to feed wildlife, right? Or to think about management without permission by the state. In the US as well, there's, in the EU, there's oftentimes privatization of wild game or wild meat. So if you go to a grocery store, you can usually purchase wild game that maybe has been supplied directly from a hunter. Restaurants are the same way. You may see a sign saying, we have wild venison, courtesy of this particular hunter in this particular region. They also have a lot more game farms as well in Europe as a result of sort of the culture, right? But that was something that the US actually has largely rejected. There's exceptions. Idaho and Texas are kind of glaring exceptions. But through the North American model for wildlife conservation, one of the main tenets is no commercialization of wildlife, which means wild game and wild meat, and we really frown on wild game farming because it's an opportunity for disease spread. And also, if you think about wildlife as a public trust resource, the idea of farming them is kind of contrary to that notion of a public trust resource, or also then making money off of a public trust resource. Okay, let's move on to talk about bird conservation. So I mentioned the Migratory Bird Treaty Act was based on a treaty in 1916 originally with Britain, and then expanded Britain for Canada, and then it had expanded to include Mexico, Russia, Japan, and Great Britain itself. And it was a result of this hat craze. So that's quite an interesting hat that Madeline included on this slide. Yeah, so in general, the Migratory Bird Treaty Act prohibits the take of migratory bird species without prior federal authorization. And here's what is all included with take, so pretty expansive definition of take. I would say there is a pretty robust debate in the United States as to whether it's deliberate take and intentional take or just deliberate take. So different presidential administrations have made arguments for either for or against that definition. And so right now it's incidental take as well as deliberate take. But I would say that's kind of an ongoing debate. Okay, so the main point takeaway here is no killing, capturing, trading, or even pursuing of migratory birds. And we're also pretty strongly protecting their nests, their parts, their eggs as well. Because again, if you think back, a lot of the early concern about really the huge declines of birds in the US was a result of their parts to be used for the creation of beautiful hats. So it does include misdemeanor penalties and felony penalties depending upon the severity. And there's prosecutorial discretion, so the Fish and Wildlife Service would be the ones who would work with US attorneys and states to bring charges under the Migratory Bird Treaty Act. And so they're not really excited to bring these charges unless there's a pretty intentional take going on. And they're going to issue warnings and try and work with the violators ahead of issuing fines. But you do see it particularly in the energy space. So there have been some pretty big cases where oil and gas operators haven't followed the Fish and Wildlife Service recommendations about putting nets over oil pits, and they have killed quite a few birds. And so then you'll see fines enforced and US attorneys getting involved in prosecuting those cases. So how do you know if a species is protected under the Migratory Bird Treaty Act? Well, you have to go to the Code of Federal Regulations and you have to look at the list of protected species. And it's pretty interesting, some of the birds that are on there, that they may not even necessarily be what you consider a migratory bird species. So, but if they're one of the 1,000 species listed, they need to be protected under the Migratory Bird Treaty Act. Quick question, does anybody know what is the leading cause of death for migratory birds? What are the top 2 causes of take of a migratory bird? Any ideas? Yeah, go ahead.
Airplane.
No, not airplanes. Something even more domestic than airplanes. You lower to the ground. Drew, did you want to? Yeah.
I was gonna guess window.
Yeah, houses, buildings are number 1, and no, are number 2. Number 1 is domestic and feral cats.
Oh.
Yeah. So if you have a cat, consider maybe keeping it inside or encouraging it not to kill migratory birds. You will not be found liable, but yeah, I don't know. Maybe if your cat's really lethal, maybe. And it is native species only. So there's a whole debate about swans on the East Coast, the trumpeter swans versus the native. I don't really know that much about birds. So
I'd like to give a shout out to Rhiannon online. Who put in the chat cats and windows as
that's because Rhiannon took my wildlife law class. Remembered. Thank you. Yeah, but you can get prior authorization, and this is something that's really coming up in the renewable energy space, because if you put a wind turbine, it's probably going to kill some birds, maybe solar panels as well. So like trying to think about how we can encourage renewable development and still stay within the confines of the Migratory Bird Treaty Act, because unlike the ESA, we haven't amended the MBTA to allow for specific take permits. So a lot of people have suggested that would be a really great thing to do, particularly as we're trying to expand infrastructure around renewable development. But Fish and Wildlife Service can give out some permits, and there are some exceptions written into the statute as well, including some hunting statutes. So if you are hunting mallards or something, you're doing that under a specific authorization. Yeah, Mallard put this in there. Use some Stranger Things, I don't know.
Thanks for the
And then let's switch over and talk about the Habitats Directive, or sorry, the Birds Directive of the European Union. So what's cool about the Birds Directive is it not only includes bird species, but it also includes their habitat sites. So it kind of goes beyond, above and beyond the Migratory Bird Treaty Act. So let's explore that a bit more. So in general, this provision basically says no deliberate, not intentional, right? They're very specific to say deliberate. So if you accidentally kill a bird, you're okay in the EU Birds Directive. So no deliberate killing, capture, disturbance, or keeping of birds, their nests, or eggs. And here you see member states shall prohibit. So the burden is pushed down to the member states to implement. And if they're failing to implement, if they're not abiding by the shall prohibit, then the European Commission can bring a complaint, and then ultimately it can be decided by the European Court of Justice. And so that has happened where they, feel like a member state's implementation of the Birds Directive is weak, and so they'll go in and ask them to revise that. And NGOs and the public plays a role in alerting the Commission as to violations. So that's similar to the U.S. system where we have citizen suits. So yeah, and also it occurs all species of birds in the European Union, naturally occurring and in the wild states. So they have a list, but ultimately you have to go back to this definition of really all wild birds. So it's not just migratory birds, it's really all birds. And there aren't any specific exceptions, and it includes about 500 species of birds. So the US, it's 1,000, where the European Union is about 500 species. But again, the same similarities of naturally occurring where we have native species. There are some exceptions. So there is some hunting subject to conditions. There is some trading as well, subject to conditions. And also some exceptions to allow take if you're protecting an airport or airspace. But here's the really cool part about the site protections, the habitat piece. So basically what this section is saying is that there's an obligation of member states to preserve, maintain, and I think that should say establish, not reestablish, bird habitat. And so if you're doing that, you're creating what's called a species protected area, or an SPA. And those, along with SPCs of the Habitats Directive, which are species conservation areas, make up what is called the Natura 2000 Habitat Conservation Network of Europe. I always think that is like, just makes me think of robots, Natura 2000.
Yeah.
But it's pretty cool, and we'll talk about this more in the habitat section of the presentation. But this is really where we see a departure between the US and the EU, are these habitats in the Birds Directive, specifically requiring habitat designations and creations of SPAs and SPCs. We have critical habitat for under the ESA, but it's different than this, because this is really thinking holistically about the whole network, and includes I'm getting ahead of myself, but it can include private land in the designation of SPAs and SPCs. Yeah, and so if it depends upon if a species is listed under kind of most critically conserved, or what am I trying to say? So species at risk birds require sort of immediate designation of conservation areas and conservation measures, and then you have different sort of categories of listing, not dissimilar from how we think of like endangered and threatened species in the US. So here's some takeaways with regards to bird protection. So in the US, we're protecting species from take or trade. Same under the European Union, plus the addition of habitat, which we don't have under the MBTA. We're prohibiting direct and incidental, which you could also interpret as intentional versus unintentional. That's a sort of debatable point right now. Whereas in the European Union, it's really clearly specific, just deliberate or intentional killing and capture. Federally implemented in the United States, where it's member states implementing in the European Union. Okay, species conservation, these are my slides. So again, purpose of the Endangered Species Act is to conserve species and the ecosystems upon which they depend. It is a federal law, and it does require the designation of critical habitat to really get to that ecosystems upon which they depend language that's set out in the statute. it's implemented by two major federal agencies, the Fish and Wildlife Service for terrestrial species and the National Marine Fisheries Service, which is under the Department of Commerce and NOAA for marine species. And we do have two different layers of listing. I have three if you count candidate species, but that's getting into the weeds. But the most critically endangered species are called endangered species. And then species that we're concerned are going to become endangered, we call threatened species. And if you're interested in more of this, please take my wildlife law course in the spring. I have a few alumni from the class you can speak to about it. And a really specific process for how we list endangered species, how we delist, and how we uplist or downlist species. And that's found under Section 4 of the Endangered Species Act. And it includes a list of 5 factors, and those are the only 5 factors the agencies can consider when making those decisions. So it's a really strict administrative process. We're not, there have been cases where there have been allegations of political pressure in listings that judges have said, that's not allowed, it's the 5 factors and that's it, go back and redo this. No consideration of economics in listing decisions either, it's just those 5 specific factors. And so in a very strict process, where there is opportunity for public involvement and ultimately the opportunity to appeal or litigate at the end of the day if you feel like the agency hasn't reasonably done their job of assessing those factors and making those decisions. So a really pretty strict administrative process. I'm not naive to think that economics and politics don't come into those decisions, and there's been some really interesting scholarship to say that obviously this happens and we should acknowledge that it happens and we should be more inclusive and transparent that it is happening in the process, but in theory, it's supposed to be, pretty cut and dry administrative decision-making based upon the best available science is actually the standard. And then the teeth of the Endangered Species Act come from Section 9 of the Endangered Species Act. So I told you this was a lighthearted presentation. So this is the Tiger King. Do you guys know he lived in Laramie? He went to high school in Laramie High for so there's a Wyoming connection. But is now spending time in federal prison as a result of violating various provisions of both the Lacey Act and the Endangered Species Act. So this is the teeth of the Endangered Species Act, which prohibits the take of endangered species, which has been interpreted to include habitat modification that actually does end up taking an endangered species as well. Unless, and here's where Congress originally didn't have a take permit written in the Endangered Species Act, but they went in and they amended and included an incidental take permit under Section 10 of the Act a few years after it was implemented, because the political reality is we have to allow some flexibility, so we have to allow some take. So let's move over and talk about the European Habitats Directive. I love this picture. It's a European hamster. I really wanted to see one while I was over in Europe, but I did not have the joy of seeing a European hamster. This was a big controversy in France. So there are European hamsters in France. Apparently European hamsters are pretty feisty, like they're pretty aggressive. And they are also in Eastern Europe, but they are declining in France as a result of habitat encroachment. So there have been some cases in front of the European Court of Justice with regards to the European hamster and the need for France to do more to protect their habitat. But what I'm talking about with this slide, not just the cute little hamster, but cute little but feisty hamster, is that there are species protection components within the Habitats Directive, which some European scholars have said is sort of the forgotten part of the Habitats Directive, because people like to focus on the habitat protection piece of it, which I'm going to talk about in a minute. But there is also, quite a bit in there with regards to species conservation as well. And so its purpose is written here. What I think is really interesting about this definition is this idea of community interest. So it's species of community interest at a favorable conservation status. So I'll mention this now, maybe mention it again later. When species are listed to the Habitats Directive, it's more of if you were to add species now, it's a political negotiation. So it's most often happening when new member states are added to the European Union. So it's based upon community interest, right? So is there interest within the European Union of seeing this species conserved? So inherently that means it's more of a political process because you want the community interest in species versus, recall the Endangered Species Act was that really administrative 5-factor analysis that was based upon best available science. Certainly science plays a role in this, just interesting how we're already starting to see some differences, even if in the definition of the purpose of the acts. Yeah.
So then, is there like a voting process?
Yeah, ultimately it would go, so all of the members of the European Union would ultimately vote. And it's a unanimous decision, so it's a pretty high bar. So I'm doing some work on what I was mentioning with carnivores. So we're at the point where delisting wolves in Europe or parts of Europe is probably starting to make more sense and have more political support. But a challenge right now, because they don't have a delisting mechanism like we have with Section 4 of the Endangered Species Act equivalent under the Habitats Directive to delist. It's more of a political negotiation. So like the Endangered Species Act in the US, the Habitats Directive includes sort of a tiered approach to species listing. So if a species is listed under Annex 2, it requires the designation of an Special Area of Conservation, or an SAC, which again is part of the Natura 2000 network. Annex 4 species are animal and plant species that are of community interest and in need of strict protection. So think about Annex 4 as like the equivalent of endangered. And then Annex 5 are animals that we're concerned about, but you could take in the wild subject to management measures. So hunting could be allowed. So that's kind of more maybe like a threatened species equivalent. And here's some pictures of different species. And a species listed in Annex 2 could be an Annex 4 or an Annex 5 species as well. So they can be listed in multiple areas. Okay, yeah, so this is the big takeaways here. So recall we had the amendment to the ESA to add incidental take permits. Under the Habitats Directive, we have what are called, wait, no, I'm getting ahead of myself. Okay, sorry. So this is the teeth of the Habitats Directive. I was thinking this was the derogation slide, but I'm not there yet. So this is the teeth of the Habitats Directive for species conservation. It's Article 12. You can see the language again. It says member states shall. So it's again putting the burden on the member states to implement and protect these species. And they have to protect against deliberate take, not incidental, deliberate take, that may impact breeding sites and resting places, and obviously the species themselves. And at the bottom are two kind of big cases of the European Court of Justice. The first is what's called the Greek sea turtle case. There were sea turtles hatching on the beach, and Greece had kind of put some protection measures in place, but there were still people like driving scooters and things on the beach, and so it was deemed not sufficient. So the European Court of Justice said you have to put a system of strict protection for animal species. It needs to actually be strict protection. Yeah, go ahead, Tilly.
Just going back to the previous slide, like if there's an animal that has designation in both, like the bison, is it for the same range, or is it like Annex 2 in one part of its range, then Annex 4 or 5 like in the other part?
There are exceptions because again of the political negotiation. So I'm thinking about so Sweden came into the European a little bit later. So for example, the wolf was listed as an Annex 4 species, but when Sweden came in, they had a political negotiation to allow the wolf to be taken in the reindeer herding area of northern Sweden. So you can have differences in member states where there may be some exceptions in specific areas for specific reasons. Yeah, but in general, I would say anywhere it's found, you should be conserving habitat and strict protection unless there's some sort of exception. Yeah, so that was the Greek sea turtle case, and then the second case here is the French hamster case. So not only do you have to put in place a strict system of protection, the Greek hamster case said you have to have proof that that strict protection system is sufficient to protect the species, and it's actually doing its intended job. So we want to see results, which is interesting, because I don't think we're quite there in the U.S. with the Endangered Species Act. We have critical habitat designation and we have take prohibition, but I don't know if we're quite as far as saying we want to see an outcome. We want to see like sufficient, that this is actually working. So is this an obligation of results as a result of the interpretation of the European Court of Justice? Okay, now I'm where I thought I was, which is derogations, and this is Article 16 of the Habitats Directive. So you can get a derogation from Article 12, which is the teeth, if you meet these criteria. So one, there can be no other satisfactory alternative. The derogation is not detrimental to the maintenance of the population, and the population has to already be at a favorable conservation status in their natural range. And then the derogation has to be necessary for one of the 5 listed factors. So this is more strict than the take permits under Section 10 of the Endangered Species Act, because we're allowing take as long as you develop a habitat conservation plan and your take is incidental to an otherwise lawful activity. But we're not saying first the species has to be recovered at a favorable conservation status before you can get your take permit. So the Habitats Directive is a higher bar than the Endangered Species Act in the US. So derogation is really a last resort, where in the US a take permit is pretty much run of the mill, an everyday kind of thing. And then there was this really interesting Finnish wolf case, and it's the member states that are granting derogation, and then the European Commission kind of annually reviews their derogations to make sure they're appropriate. And so Finland has wolves, and they were wanting to allow kind of broad hunting of wolves because they were having some livestock depredation. And livestock depredation is one of the qualifications of that last bullet point. So it's listed as one of the 5 community interests. But instead of targeting the wolves that were depredating livestock, they just wanted to issue like a general hunting season. And the European Court of Justice came back and said, no, first of all, that's not specific enough because derogations are kind of last resort. You haven't shown us that the Finnish wolves have reached favorable conservation status, nor have you sufficiently scientifically demonstrated that this general hunting season is going to address your problem, which is depredation. So they did not approve that ultimate derogation by Finland with regards to wolf hunting season. So what are some big picture takeaways? Again, more administrative procedural in the US with regards to listing, delisting, uplisting, downlisting. Whereas in the European Union, more of a political negotiation that does include scientific assessment, but ultimately we want feedback from the community. Is this a community of interest of the species? You know, how does the public feel about delisting or listing a particular species? In the US, we are prohibiting deliberate and incidental take for most listed species, whereas in the Habitats Directive, it's really only deliberate take. Incidental if it's a breeding or resting site, but as long as it's not that, we're just focused on deliberate, intentional take. And you can get a habitat, you can get an incidental take permit under Section 10 pretty easily. And again, that's a harder bar to cross for a derogation under the Habitats Directive. Okay. I'll try and get through this quickly. So this is, again, these are Madeline's slides to give her credit. But let's talk about habitat conservation with regards to the US and the EU. So under the Habitats Directive, again, we are automatically designating sites. Both, I haven't talked about this yet, but under Annex 1 of the Habitats Directive, there's actually a list of different types of habitats. And there's requirements for member states to go ahead and designate habitats with, regardless of if there's species of concern there. These are just habitats we're concerned about protecting. So like high alpine areas, areas along the coast are critical concerns. So regardless of species concerns, we're concerned about this habitat, about this ecosystem, and your member states are required to designate them. And the same is true for Annex 2 species, if you recall. And then there are management requirements for different species under Annex 4 or Annex 5. So let's jump into that a little bit more. And they all create the Natura 2000 network. And if an area is included under the Natura 2000 network, then we kind of have what's like a NEPA process that applies. So if you want to go ahead and develop or take some sort of management action within a Natura 2000 site, you're going to have to identify what you're going to do, analyze the impact, think about ways that you can mitigate the impact of that development within the Natura 2000 site. This is a map of the various different SPCAs and SCAs within the Natura 2000 network, which you can see that's quite a bit of coverage. And they so they also have a common goal of 30 by 30 as well, like the US, and they're about 18% of the way there just based on the Natura 2000 sites. And it is the largest coordinated network of protected areas in the world. And the aim is ultimately to protect vulnerable habitats, so not just species, but habitats themselves and species, and ensure they're restored to or maintained at a favorable conservation status. What is so interesting about Natura 2000 sites is that they can include private ownership. So you could create an SPCA that includes maybe some state land, maybe a member state national park, and maybe private land as well. So that's out of necessity, right? They didn't have the luxury of this vast federal public land system that we have here in the US. So you have to think about how can we conserve habitats based upon the fragmented landscape that we have in Europe. So it's a network. It's not a system of strict nature reserves, it's a network, and there is flexibility in management as a result of the reality that you include private ownership. Yeah, so here is some of the requirements with regards to habitat. So this is the procedure for development. So there's a screening tool, an assessment tool, and then you can have derogation. So if you're not protecting the habitat, you can go ahead and do that. But again, it's a pretty strictly controlled process. So you can kind of see how that starts to look a little bit like our NEPA process for those of you who are familiar with that here in the US. I'm sorry, I'm going fast, but I want to make sure I save time for questions at the end. And then in the US, it's our habitat is largely based upon federal public land that was left over or designated through various different statutes and managed then by various different agencies that we're going to talk about here. And this is a map showing in yellow or orange Bureau of Land Management land. So this is public domain land that was left over after homesteading. Dark green are national parks that were reserved for specific purposes. Forest Service are light green, and then the light blue are Fish and Wildlife Service lands that are national wildlife refuges for the most part. So yeah, Alaska is always such an interesting case to look at because they have a lot of BLM land, particularly up north, and then they have a lot of Fish and Wildlife Service and wilderness stud. No, what am I trying to say?
National
wildlife refuges. Thank you. And these, some of these are multiple use lands, right? So they're managed for the public's benefit. We call federal lands public lands because they're ultimately managed by Congress, and Congress ultimately responds to the people who elect them. And so they're managed for the public for various different uses, including recreation, sometimes wildlife and ecosystem protection, cultural heritage, and resource extraction and use as well. So multiple land management. So unlike the Habitats Directive, not just a focus on habitat conservation with derogations, but more so a mix of multiple uses that need to be accommodated. And these are the agencies that are primarily managing federal public lands. And Madeline included this because we're presenting to a European audience. So we were just noting how creative the National Park Service has been with their Twitter account. So yeah, did you know if you hold an air mine up to your ear, you can hear what it's like to be attacked by an air mine? Or if you come across a bear, never push a slower friend down, even if your friendship has run its course. So and this slide just was kind of educating that European audience of the various different types of public land designations across the network of federal public lands. And in particular, starting with the Wilderness Act, these are wilderness areas can occur on National Park Service land, they can occur on BLM land, Forest Service land. So the agency upon where the wilderness area is designated ultimately manages a wilderness area. And under the Wilderness Act of 64, there are areas that are to be preserved in wilderness condition where the earth is a community of life untrammeled by man, and where man himself is but a visitor who does not remain. But to me, when I read the language of the Wilderness Act, this is still really anthropocentric, right? We're not talking about habitats, we're not talking about species, we're talking about man enjoying this open space. But I think kind of de facto wilderness areas are also, habitat refuges for a lot of species, but not the purpose I see when I read the text of the Wilderness Act. National parks, and again, we can look at the National Park Organic Act, but then we also have to look at each individual organic act that created each national park. But in general, these are areas where we want to preserve unimpaired natural resources, oftentimes for public enjoyment, education, and inspiration of future generations. So a bit of like preservation of natural, which we can include assumes wildlife in their habitat with regards to National Park Service land. Forest Service has to follow both the National Forest Management Act and the Multiple Use Sustained Yield Act. And the Multiple Sustained Use Yield Act has a list of multiple uses the Forest Service has to accommodate on their lands, which includes wildlife and fish in particular. And national monuments, which are designated by presidents under the authority of the Antiquities Act. So we gave this presentation in May, and the new national monument had just been designated by President Biden in Nevada. And these again are to protect cultural and natural resources and to set aside for permanent protection, but may allow some continuing uses. So big picture takeaways with regards to habitat. Habitat directive is actually comprised of mostly private land, which is really interesting, where conversely, it's mostly public land here in the United States. It's this network of habitat sites, and they're thinking about conservation and connectivity as well when they're designating these sites. Whereas we have the system of protected reserves, which are kind of isolated oftentimes and a result of sort of homesteading laws and how the West was sort of divided. And a pretty Western focus, right? If you think back to that map, it's pretty Western focused. Development that adversely affects habitat is for the most part prohibited under the Habitats Directive, although there are derogations that are allowed and grandfathered in activities as well. Whereas in the US, it's development according to its designation status. So is it BLM land? Is it Forest Service land? Is it National Park Service land? So it depends upon what type of site it is. And Madeline came up with this great analogy where the European Habitats Directive is kind of like a marbled steak, right? So you have this historic landscape where you don't have lots of open space. So we're creating protected habitats where we can. So it's kind of a marbled steak, it's dispersed. Whereas in the US, it's more like, your family can't decide on pepperoni versus cheese pizza. So this part's protected, so it has no pepperoni, it's just cheese. Where we have development kind of more concentrated on the pepperoni side. So if that makes sense, but I thought that was kind of a nice way to think about it, is we're just really focused on private lands, federal public lands in the US, although Drew and others are doing great work to think about private land conservation, but just the way our laws are structured, that's been the historic focus, where that's just not a reality in Europe. So they have to think more about inclusive habitat designations. So member states can manage conservation areas with directives and also can allow derogations. And federal agencies manage in accordance with various US laws here in the United States. So another big difference. And I think with that, I will open it up for questions. So thank you for your attention. Yeah, please.
So with the EU having so much focus on the private lands, are those landowners like financially responsible for any type of like habitat preservation or anything like that? Or do they get like subsidies for that?
Yeah, that's a good question. I would say in general, there's a lot of subsidies in the European Union, just like we probably see in the United States, but maybe even more so in the European context. I don't know, I haven't studied that myself specifically, but I would say there's lots of opportunities for funding. But ultimately, like, they're restricted from developing as a result of being included in a Natura 2000 area. I don't think they would get compensation for that lack of being able to develop, because I think it's seen as like, it's your duty to preserve this habitat and wildlife. So you don't have that right to develop if it's going to impede sort of this public resource of habitat and wildlife. Good question. Yeah.
What would you say would be like the difference between people in the EU versus the US, like how they feel about different land management?
Oh, that's a good question. Yeah, it's interesting. And I think it's country specific, right? So it's hard to speak for the European Union, when each country is managing under the Habitats for Birds Directive a little bit differently. And so I think the public have different sentiment. But I guess in general, I would say, I don't know, Mark, I hate to speak for the European continent when I'm not European myself. Do you have thoughts on how to answer that?
It's true that it really like depends on the country you're looking at, but I would say that specifically for like habitats or even like with the species, there's a little bit more like also political interest and like the predation when it comes to carnivores. So there's like more debate whether like, yeah, we like this rule or we don't. But with habitats, it's really just, it is what it is, and it's protected and it's not a big deal. Like it's just something that it is that way, and there's not a lot of concerns or like arguments about what should or should not be protected in a specific land.
Yeah, and I think there's some political science research that shows like Europeans in general are more willing to accept regulations or restrictions on their really environmental regulations and restrictions in the US.
And I think it's also based on the history of each, the US country versus Europe in terms of like how many years we go back. I feel like under the civilization point of view, if that's the word that you want to use, but like we go all the way back to the Roman Empire. And so it's just something that has always been like that. Regulations and like laws and how make things work is the only way. Well, here, like after, like all the colonies, it was kind of like creating something new, and so I think that there was a lot more debate on how we wanted to make things instead of like, oh, it has always been like this. It's just like a progression and that type of path that was already taken.
So I was mentioning I'm doing kind of some follow-up work with regards to carnivores to give you an idea of how different member states view different species. So I was looking at wolves in particular when I was over in Europe, and Mari knows this quite well. There are around 3,500 to 4,000 gray wolves or wolves in Italy. In Germany, there's about 2,000, whereas in Austria, which is kind of connecting Italy and Germany, there's 23 wolves. And so that just gives you a sense of like how different member states have different political tolerance for different carnivores. And actually, there's been some documented studies about how poaching is socially tolerable in Austria for wolves because there's just no public support for carnivores in the state. So it just shows you how different across these very close European countries the political sentiment is with regards to different species. Yeah.
And I would say the Italians are pretty sentimental, so.
Yeah, and so I was also reading some really interesting papers about how the story is that Rome was created by two wolf brothers, right? Yes. And when you're in Tuscany, you see mother wolf, and so wolves are more ingrained in sort of the cultural attitude in Italy, so there's more social tolerance, and they never left the landscape either. So there's knowledge of how to live with wolves that remains in the culture.
So right at 12:50, if people need to get up and go on to your next obligation of the day, please feel free to do so. But if there's a couple more questions, if people are able to stick around, then that's simple. Time for a little more questions.
Yeah, right.
So if you had to take one thing from the US system and put it in the EU system and vice versa, what would you do to improve each of these sides?
That's a great idea. I think if I were to take something from the US and take it to the EU, I would instill a more publicly transparent process for listing and delisting that's more administrative and based on science and less on politics. And if I were to take something from the EU back to the US, I think I would take this notion of like favorable conservation status. And so, being maybe a little bit more strict about take permits in particular. So you need to make sure you reach some sort of favorable conservation status before you're issuing take permits. Would be, I think, what I would take cross back and forth.
The private lands, marbled state.
Oh, and the private lands marbled state. Can you imagine trying to implement that though nowadays in the US? Like, I don't think we should. Yeah.
Any last questions?
Great, well, thank you guys for
Thanking
your
Temple.
time. Yeah. A little lighthearted and fun, but there's more to come in this.
And I will just put a plug in next week. Our very own Mari here will be presenting animal personality and its role in wildlife conservation. Who's in charge of introducing Katie? So if you want to connect with Mari and work on your introduction, we'll look forward to hearing from you next week, Mari.
Yeah, I already bother her for an hour yesterday.
I couldn't stop asking questions.